So now the police are at your house trying to help your kids who are abused, and you're preventing them from doing it. It's clear she's not going to work with anybody. She wasn't cooperative. She was rude. She's right here says she's not going to be able to comply with conditions of her probation.
Versus Kayla Thuransky, file 25 CR 787. We're here today for a change of plea. It's anticipated by the state of Ohio the defendant will withdraw her previously under pleas of not guilty and under pleas of guilty to count 1. And in exchange, the state of Ohio will ask the court to nullify the remaining counts at sentence. Other than what's been spread upon the record, no threats or promises were made to this defendant to induce his plea. Thank you.
Trelane, Mac, does that sound accurate?
It does, Your Honor.
Where's Taylor?
She's at a doctor's appointment.
Okay. Ms. Thuransky, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here today?
Yes.
They've indicated to the court they believe it's your desire to withdraw your previously entered plea of not guilty and plead guilty to count 1 of this indictment, obstructing justice. The other counts would be dismissed. On count 2, if the same charge, that would get dismissed. We would defer sentencing to a later day to get some evaluations completed, come back on a future day for sentencing. Where there's no agreement between the parties regarding any recommendations, each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes.
In that indictment, you're charged with 2 counts of obstructing justice. You're pleading guilty to the first count. And what's alleged here and what you're admitting to is on or about May 23rd, 2025 in Mentor Lake County, Ohio, that you did with purpose to hinder the discovery, apprehension, prosecution, conviction, or punishment of Cody Molnar for a crime, or to assist Cody Molnar to benefit from the commission of a crime, that you harbored or concealed Cody Molnar. The crime committed by the person aided, Mr. Molnar, was a felony of the 3rd degree, which makes this offense, obstructing justice, a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in count 1?
Yes.
Any questions about it?
No.
Now, as far as sentencing goes, you're pleading guilty to a felony of the 5th degree. This offense is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. You understand that?
Yes.
Mr. Geigerich?
Thank you, Your Honor. The evidence would show that on May 23rd, 2025, Mentor officers responded to 7510 Murray Avenue in the city of Mentor Lake County, Ohio, in order to serve a warrant on Cody Molnar. He had a warrant out of Mentor Municipal Court for endangering children, and he was living at that residence. Upon their arrival, they observed the vehicle in the driveway registered to Molnar's girlfriend, being the defendant. Every window to the home, including the window to the front door, was covered by black plastic, which would appear to be garbage bags. They heard dogs barking in the garage. No cameras were observed, but a basic doorbell at the front door. They knocked several times, but no one answered. They called the listed phone numbers for the defendant and Cody Molnar, and left voicemails. A short time later, dispatch advised that the defendant had called and was requesting a callback. The officer spoke with the defendant on the phone. She stated she was at work, and she stated she knew the officer was there because her doorbell takes photos when someone rings it. She advised that she'd kicked Cody Molnar out of the home a while ago and hasn't heard from him. He might be living with his mother in Euclid. The officer spoke with the reporting officer on Cody's case. Per Job and Family Services, neither the defendant or Cody Molnar have jobs, at which time they returned to the residence, knocked and announced the officer's presence, announced that they knew Cody and the defendant were home, and that the defendant would be criminally charged if she didn't open the door. She opened the door and let the officers in, and was advised they needed and she was advised they needed to search the home for Cody Molnar. She said Cody Molnar doesn't live there anymore. She was displaying nervous behavior. The defendant made a comment about a pit bull being loose in the garage because the kennel was broken. Said if officers search, she has to go in there first to control the dog. She continued to tell the officers that Cody wasn't there. When officers started walking towards the garage, she hurried past them and entered the garage first. When the officers entered the garage, they found Cody laying in the bed pretending to be asleep. The dog was already in a kennel and not loose. At this time, Cody Molnar and the defendant were taken into custody. Thank you.
Mr. Ansky, were you able to hear what the prosecutor had to say regarding what he believes the evidence would show if we had a trial?
Yes.
And what, if anything, do you have to say about those facts he presented them? Are they true? Did you do what he said?
Yes.
Very well, then, regarding count 1, charging with obstructing justice, a felony of the 5th degree, what is your plea to that count?
Guilty.
Very well, then, at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with her lawyer, advised of all her constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant guilty of count 1, obstructing justice, felony of the 5th degree in violation of 2921.32A1. Count 2 will be dismissed at sentencing, but sentencing will be deferred in order of pre-sentence report and investigation. Any other reports that you're requesting?
No, Your Honor.
I'll continue defendant's bond at her own recognizance with the condition that she have no contact with her children and report to adult probation every Monday. So what all this means, Ms. Thuransky, is in regards to bond, I'm not changing it, so you need to, you're going to be free to go. You just need to continue complying with the conditions that have been in place. One of the conditions, aside from what I just said, is also that you don't use any drugs while you're on bond. You have to submit urine screens if they're requested. They have to be negative. A positive screen will be a violation of your bond, and a warrant would be issued. You understand that?
Yes.
Now, the whole purpose of this report is so I can learn more about you. And the way the probation department gets the information they need to prepare the report is they have to conduct an interview with you. So it's important here that you be open and honest with them when you're answering their questions and filling out the paperwork, because if they learn you're misleading them in any way, it could be flat out lying, or it could be exaggerating or minimizing something. Anything, they'll let me know that, and I'll consider that at sentencing. You understand that?
Yes.
Shall I make anything else for the record?
Yes, Your Honor. As to the bond,
Okay.
to address that, we would ask that you modify it to take away the no contact with children, leave everything else in place.
Well, it's no contact with her children, not any children.
No contact with her children, I apologize.
I'm not changing anything at this point. I don't know anything about this.
I know currently she has a JFS case, and they've been waiting to see what happens here, but
What's been waiting to see what happens here?
Custody.
the custody issue with them.
So where are the children now?
With their dad.
What was Mr. Mueller's case about? That was a child endangering case, right?
It was involving the defendant's children. He burned them with a curling iron to punish them. He's currently in prison
Yes,
for
I
12
know, I
months.
see that. Okay, well, I'm not changing any conditions at this point. We can address that at sentencing.
Okay. Nothing further.
Anything else for the record, Mr. Bagridge?
Nothing, Your Honor.
As I said earlier in chambers, obviously this wasn't the best course of action for Mr. Ransky when the officers got there, and while they were looking for Cody, she obviously did not want to let them arrest him. She didn't want him to go away. It was not a great call. It was not the right call. It's obviously why she pled guilty to this. She's currently, as you're aware, she has a case across the street in juvenile court with JFS. They're handling this. They're handling the issues with the children, with her children. It's still in progress. It's still ongoing. She wants to move forward from this case, Your Honor, and focus on JFS. They have a case plan. They have things that she needs to do with them. My understanding, she has been doing, but needs to do more and needs to keep doing. It's the standard way across the street for JFS. They want to see you do things, and they want to see you do them for a while to make sure that you are actually doing what you need to do and they feel that you will continue to do so, not just for a week or two or a month. Your Honor, we ask you to take these things into consideration. The fact that despite her being sentenced today and being on probation with here, she is still dealing with the courts directly as far as juvenile court in regards to the children, which I think kind of are should be at the root of all of this and should be in her thoughts primarily. I mean, she needs to get herself right, but she needs to do that not just for herself, but for her children, because their children need a father, they need a mother, they need both. She needs to be the mother half of the children. She needs to start making the correct decisions for them because of being their mother. Your Honor, we ask you to allow Ms. Staransky to be on community control, to be able to be out of jail and doing what she needs to do to work with JFS, to work to better herself. Just consider these. Thank you.
Thank you. Mr. Ransky, you have the right to address this court before your sentence. You can say anything you want. Is there anything you want to say?
No.
Okay. Mr. Langmack, anything else?
Nothing further, Your Honor.
Ms. Linden?
Thank you, Your Honor. Your Honor, although the state's not opposed to, excuse me, community control sanctions, we do believe that some jail time is appropriate. I found it interesting that in the psych evaluation, there's no mention of any kind of drug or alcohol use at all, but clearly there was in the pre-sentence report. In the pre-sentence report, she says that she has been sober for 6 months, but that she last used in May, and I know my math in this court isn't always the best, but it means that there was just some additional time in there that she was using. The focus that she has so much on what happened with police in the past, she completely misses the point that this is a situation where they were coming to get Cody because he had severely burned her child, who's 7 years old, in the hand. And so it's not as if she didn't know why they were coming, and even if they wanted just to come and talk to him, to lie to the police was not appropriate. And so looking at this and looking at the history and what she talks about with the way that she was treated by her stepfather and what she went through, I guess I'm a little concerned that perhaps maybe her thinking, and especially keeping Cody safe while not keeping her children safe, there's an issue there. So we are asking that there be some jail time imposed. Again, we're not opposed to community control. She does have 12 days of credit for time served. Thank you.
Thank you. This court has reviewed the pre-sentence report, investigation, the psychological evaluation, consider the facts and the circumstances of the offense involved, the nature of the offense involved. I've considered what's been said here in court by Mr. Langmack on behalf of the defendant, the prosecutor, and the recommendation. I afforded the defendant an opportunity to make a statement. She chose not to, which is fine. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 2911. Other relevant factors, just the prosecutor touched upon this, but you're obstructing the police in investigating a case involving abuse to your children. And the whole reason you're giving for doing that is that the police didn't help you when you were growing up and you were abused, and they didn't help you.
No, and that's not...
That's what you said.
Well, that was a reason, but it wasn't the reason.
Well, I'm speaking now. I gave you a chance to speak, and you chose not to make it. But you've said it repeatedly in your pre-sentence report. You even wrote it down. Well, I don't like police officers. Growing up, they did nothing to help me when I was abused. She states she lied to the police because she does not trust them. She reported while growing up she was physically abused by her stepfather, and the police did nothing to help her. You wrote that down. So now the police are at your house trying to help your kids who were abused, and you're preventing them from doing it. The overall circumstances around this obstructing, or make it more serious than the normal obstructing. When the police are there to arrest the person who abused your children and you're protecting the abuser, and trying to let him stay in the house, it makes it much more serious. Nothing makes it less serious. As for recidivism factors, the court finds the defendant has a history of criminal convictions and juvenile delinquency adjudications. The nature of those causing concern because they are all of a violent nature. I mean, the juvenile delinquency is domestic violence, domestic violence, domestic violence, domestic violence, assault, aggravated menacing. As an adult, you have disorderly conduct and a domestic violence. Now, I will note that the last offense of that domestic violence I just referred to was 11 years ago. It's the last one, but there was a petty theft in between that. A few years ago, there was a period of time where there wasn't anything. There's absolutely no genuine remorse in regards to the offense here and her conduct here. She doesn't regret what she does. She doesn't have any remorse about it. She had a horrible attitude with the probation department when she was with them. Why don't you work? You said you want to get your kids back, and that's why your focus is getting your kids back. And that just happened. Your kids were taken away just this year. You haven't worked. You capable of able to work?
Am I allowed to talk now?
Yeah.
Okay. No, I can't work right now
Why can't you work?
because I have a lot of issues that I need to take care of, and I was trying to.
Okay, well then she's not going to be amenable for community control sanctions because one of the conditions of your probation, if you're put on probation, you have to get employment.
Yeah, that's not going to happen.
Huh? That's not going to happen?
It wouldn't happen, though.
You want to go?
I'm sorry?
Yeah, she's in prison otherwise.
That's not going to happen. That's what
I
she's saying.
don't even have a home right now. How would I get a job?
Well, you can try to get one.
All right, well then we're going to shift
No,
gears
she's in
here.
prison.
I find the defendant is not amenable to available community control sanctions. It's clear she's not going to work with anybody. She wasn't cooperative. She was rude. She's right here says she's not going to be able to comply with conditions of her probation. She's not amenable to available community control sanctions. Therefore, it will be the sentence of this court that the defendant serve a term in prison of 6 months. Should be given credit for 12 days she's already served. You need to advise you upon your release from prison, you could be placed on post-release control for up to 2 years. If you are and you're violating any of those conditions, the parole authority can return you to prison as punishment for violating the rules for another 3 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court just approves the defendant's placement in program of shock incarceration, intensive prison program, or transfer to transitional control. And the defendant's ordered to pay all costs. I mean, there's no reason the defendant can't work. There's no physical reason. There's no other issues like that. She just says it's not going to happen. And I'm not going to waste everybody's time here. Is there anything else for the record, Ms. Linden?